Hello, everyone. I'm in the show. All right. Welcome, everyone, to I guess we'll give it a couple of minutes to let everybody come on, but I want to welcome you to our conversations with Black women um, with our partner, EEOC. We're going to be talking about some really great stuff here today. So thank you for everyone. All right, we're going to get started. Let me tell you a little bit about who we are. It's the California Black Women's Collective Empowerment Institute. We manage the California Black Women's Think Tank at Cal State Dominguez. It's the only policy think tank in the nation that focuses exclusively on Black women and girls. We do this work through our three pillars, which is data. We do everything with data. And then from data, we go into policy change and practice transformation. We've been around since 2022. Our work that we do is to improve the lives of Black women and girls. And we do that through everything that we need. I'm sorry, we're at a conference, so we're making do. But we do that work through ensuring that we eliminate and mitigate barriers that Black women and girls face throughout California. We're really excited about the partnership with EEOC as we bring together our collective throughout the state of California and provide them with information that they can use. So I am going to turn it over to our partner, Nikki, who is with the EOC, and she's going to start. Today will be a lunch and learn. We'll be talking issues, and then from there, we'll have a little opportunity for some partners. So, Nikki, welcome. Looking forward to hear what you have to say, and I'm turning it over to you.
Thank you so much, Kelly, and thank you so much to the Black Women's Collective, because you guys have been such an amazing partner for us, giving us this opportunity to share new and exciting information with everybody here. Please feel free as we go today to drop questions in the comments. We are going to be stopping periodically throughout today's presentation to be able to answer any questions that you may have. I'm going to suggest that they are broad stroke questions because I really can't, unfortunately, get into the minute details about certain situations that may be occurring in your workplace or to you at this time or to someone that you know. However, you're going to leave here today with my contact information. So if you do have follow-up questions, you're always welcome to reach out directly to me. Who am I? My name is Nikki St. Germain. I'm the lead outreach and education coordinator and public relations manager for the United States Equal Employment Opportunity Commission. I'm based out of Los Angeles. Our agency is the premier federal agency that enforces civil rights laws. We were born out of the March on Washington. We just celebrated the 60th anniversary of the signing of the Civil Rights Act. And upcoming next year, we're going to celebrate the 60th anniversary of opening our doors. The laws that we have here protect individuals from workplace discrimination, harassment, and retaliation. And today we're going to specifically talk about the new law that the agency enforces called the Pregnant Workers Fairness Act. This law protects job applicants and employees from discrimination based on pregnancy, childbirth, and other related medical conditions. Now, before I talk about this new law, I really do want to explain briefly how other laws that we enforce also protect pregnant workers. This is not the first time that we are protecting individuals who are affected by pregnancy, childbirth, or related medical conditions. Pregnancy discrimination is against the law, and the agency has been enforcing that with the Pregnant Discrimination Act and which amended Title VII to include that it is illegal to fire somebody, refuse to hire somebody, or take any other negative employment action because they're pregnant, because they may become pregnant, or because they ask for a modification or an accommodation in the workplace. Pregnant workers have the right to be treated the same as non-pregnant job applicants or employees. And so the EEOC protects those laws. But the new Pregnant Workers Fairness Act is providing individuals who have pregnancy-related needs or accommodations, we'll talk a little bit about that, that arise out of a non-complicated pregnancy. So there have been times where we as an agency have been able to enforce accommodations for pregnant workers if their medical condition rose to the level of a disability, so it's substantially limited a major life activity, such as something like gestational diabetes. However, under the new Pregnant Workers Fairness Act, it doesn't have to be substantially limiting. It can be mild. It can be something that just needs to happen in order to continue to maintain a safe and healthy pregnancy. So when we talk about the Pregnant Workers Fairness Act, it requires employers to provide a reasonable accommodation to a qualified employee with known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, absent undue hardship. This law was put into place in December of 2022 by President Biden, and we began accepting charges in June of 2023. This past April, we finally issued final regulations regarding the implementation of this law, and that's what we'll be spending time today really talking about. But the reason that a number of these words in the previous slide were actually bolded is because we took from both Title VII of the Civil Rights Act and the Americans with Disabilities Act. Congress took those and used terminology that employers and individuals are already comfortable with in order to draft what they were looking for under the Pregnant Workers Fairness Act. This law does apply to the same type of employers who are covered under Title VII, which means it could be a private employer, a public employer, a state, it could be federal agency. They just have to have 15 or more employees for us to have coverage of it. So on this slide here that we're going to talk about next, and please keep the slide up really quick to our team in the background here. These are just some examples of possible accommodations that you can have access to in the workplace as a result of your pregnancy. So you can ask for flexible breaks. Maybe you need time in order to be able to drink water, get some rest, use the bathroom. Maybe you need to have a change in different types of policies within the workplace, such as if you have a policy that says you can't have water at your workstation, maybe we're going to have the employer look at changing that policy. Reasonable accommodations are really just changing the way that the work environment is or how things are normally done. Some other examples may be a larger uniform as a pregnancy progresses. Maybe it's adjusting a work schedule or giving individuals the opportunity to telework as a reasonable accommodation. Maybe it's something where an individual is unable to perform an essential function of their job and they have to have a temporary reassignment. Maybe they need to take leave in order to go to the doctors. Maybe they need a little light duty. Maybe ultimately they need leave in order to recover from childbirth. Under this law, there are not the limitations that might be put in place under like FMLA that requires you to have worked at a company for a certain amount of time or a certain number of hours in order to have access to FMLA. Under the PWFA, you just have to have an employer that has 15 or more employees and you have access to leave absent that undue hardship to recover from childbirth. Ultimately, the type of accommodation that you need is going to be different depending on what job you're doing, who your employer is, what the type of work is. And so every single accommodation is an individual process. And if we go to the next slide, we're going to talk a little bit about requesting accommodations. So when we look at requesting accommodations, there is no magic language that anybody needs to use. We would say that, first of all, an employee or an applicant or just their representative has to tell the employer that they have a known limitation, a physical or mental condition arising out of childbirth, pregnancy, or related medical conditions. And the employer needs to know that there needs to be an adjustment to the work environment or a change because of that limitation, right? So those are the two prongs to requesting that accommodation. We have to let them know that we have a physical or mental condition related to or affected by or arising out of pregnancy, childbirth, or related medical conditions, and that we need a change. So we don't just have a limitation, but we need to have the actual accommodation. Now, this does not have to be in writing. It does not need to be in special terms. It doesn't have to be on a particular form. You can call in, you can have a doctor's note, you can send an email, you can talk to your supervisor, a manager, HR. Has to be somebody with an authority within the company, but there is no specific requirements on how and who you would talk to in order to request that accommodation. Next slide, please. When we're looking at PWFA, we talk about a qualified person who can do the essential functions of the job with or without a reasonable accommodation. So qualified means that I can do this job, and if I have an accommodation, I can still do the job. And if I don't have an accommodation, I can still do the essential functions of the job. Essential functions is why the job exists, right? We accommodate oftentimes how the job is done, but not why it exists. And then if for some reason you actually cannot still do the essential functions of the job because of pregnancy, childbirth, or related medical conditions, it doesn't mean that you're not qualified. Under the new guidance, if you have the known limitation and you let your employer know, and you need an accommodation, they can actually look at whether or not part of that essential function can be temporarily suspended, if that essential function can be done in the near future, and if the ability to perform the essential function can be reasonably accommodated. So what this ultimately means is that if you have a situation where somebody's working in a fulfillment center and they may need to move heavy boxes in order to fill those orders, but they're pregnant and their doctor says they can't lift more than 10 pounds, that worker may still be qualified because they'll be able to go back to moving those boxes once that pregnancy is over. And so they can request an accommodation from their employer to temporarily suspend that essential function because they'll be able to do it in the near future. And that way it would be a way to still provide the person an accommodation, even if because of their pregnancy, childbirth, or related medical condition, they cannot do it right now. Next slide, please. Okay. Oh, you're on mute, Isis.
Thank you, Nikki.
You're welcome.
Thank you. Thank you so very much. We have a couple of questions. And so
I'm ready.
The first question, thank you. You're ready for it. You stated that there are other modes of communication that people can use outside of having a written note, a formal written letter. What other modes would work for communicating that I need special attention due to pregnancy or childbirth?
I'm so glad you asked, because once again, no special language is needed, no special forms. The employer can't be so stringent on what they need and who it has to go to that it makes it difficult for you to do it. You literally could pick up the phone and call work and say, I'm pregnant. I am currently experiencing severe morning sickness. I need to take some time off, or maybe I need to adjust my schedule. It could be a phone call in. It could be I had an emergency and my spouse or my partner is calling from the hospital and saying, hey, she's not going to be in tomorrow because of this. So it can be your spouse, it could be a family member, it can be a representative. You can send it in email, you can write a note, you can call in. Any of things like that are going to be a good way to ask for it. I mean, it depends on the workplace. Some workplaces, text message, Teams message, Slack, all of those are typical ways of ongoing communications. So I would never say no, but if your workplace doesn't do that regularly, don't use now to be the time that you're going to decide to ask for an accommodation via something nobody's going to check.
fair. That is fair. Okay, another question, and then we can move forward. Another question is, you talked about representative, your spouse or a family member. Could another coworker or a fellow employee also be a representative acting on your behalf?
They could be, they might not be. It depends, because sometimes you develop very close relationships with like your colleagues at work, and you're very close. And I may be experiencing an issue. Maybe I'm in the restroom and I can't come back, and my colleague comes in and says, look, just letting you know, she's currently having morning sickness. She's in the restroom. She needs to come back. You know, she'll come back when she can. That can be enough to put the employer on notice that I currently am experiencing a physical condition related to pregnancy, and that I need an adjustment to the job. So it could be something like that. But if we're talking something where we're just like, I'm going to need to take significant time off or something, it would be better if it came from a family member, a spouse, a partner, or that individual themselves. But I can totally see situations where it happens at work where it's going to be your colleague that's going to come in and put the employer on notice for a reason.
All right. Thank you so much for that. Okay, then we'll come back with more questions with the next portion.
All right. Sounds great. Thank you so much, Isis. And remember, put something in the comment section if you've got questions. We're here to answer those for you. All right. We'll do the next slide. Okay, so our known limitations, what does that ultimately mean, right? So under PWFA, you can get a reasonable accommodation as a qualified employer applicant with a known limitation. Under PWFA, that known limitation is a physical or mental condition related to, affected by, or arising out of, you're going to hear me say that so often, pregnancy, childbirth, or related medical conditions that the employee or the employer's representative has communicated to the employer. This known limitation does not need to meet the definition of a disability under the ADA. So just so that that is very clear, the limitation, right, it's really defined very broadly under the regulations. It could be modest, minor, it could be an episodic impediment or problem. It also states that limitations that the worker is seeking just to maintain the health, their health, or the health of their pregnancy. So maybe they are looking to take time off in order to go to ongoing doctor's appointments, and they need to do that in order to maintain their health or the health of their pregnancy. Something like that is a request for an accommodation. Finally, the rule states that a limitation includes when a worker is seeking health care related to that pregnancy, childbirth, or related medical conditions. And there's a very long list that we provide in our guidance on what some of those other medical conditions can be that are related to this. So maybe somebody needs an accommodation, and I mentioned morning sickness, but maybe it's migraines that are pregnancy related. Maybe you just need to go to the bathroom more because your body is now being compressed as it's growing a baby. Maybe you need to avoid certain chemicals in the workplace, or you can't work in a very hot environment, or you have to limit certain physical activities. Those types of things are examples of possibly the need for an accommodation. Maybe you need to limit your physical activity, or for some reason you need to be on bed rest. All of these things are part of the final rule. Once again, we do not have to have a definition of a disability to be qualified with a medical condition under the PWFA. All right, next slide, please. So when we're talking about, and as I said, you're hearing me use the words over and over again, pregnancy, childbirth, and related medical conditions. This is not a definition that is new to the PWFA. In fact, Congress chose to use the exact same phrasing from the Pregnancy Discrimination Act that amended Title VII in 1978. And the Commission adopted that same definition. We have done nothing different in noting this about in the difference between what has been in place since 1978 and today. Now, the final regulations also include a non-exhaustive list of examples that could be other related medical conditions. And these things can be everything from miscarriage to stillborn. It could be your gestational diabetes. It could be hormonal or menstrual. It could be incontinence. It could be things like developing sciatica that not only happens during pregnancy, but can continue afterwards. Things like carpal tunnel syndrome. It could be having mental health disabilities during your pregnancy that then could also continue. Maybe we have a situation where an individual develops depression during pregnancy, and then they end up with postpartum depression afterwards. All of these things are other related medical conditions that arise out of or are part of pregnancy, childbirth, or something that is related to that. Next slide, please. Now, the employer does not have to give an accommodation if they are able to show that the accommodation the individual has requested is an undue hardship. That is the employer's defense to not providing an accommodation. Now, an employer does not have to make that accommodation if they can show that undue hardship. And the undue hardship standard under PWFA is the same standard as under the ADA. Once again, Congress adopted the same type of language under the Americans with Disabilities Act and put that into here with the Pregnant Workers Fairness Act. So under this, there are certain determining factors that we use to say whether or not an undue hardship is actually occurring. It can't just be, we don't want to do this, or we don't want to create an environment where other people may now think that they can also ask for accommodations. And we don't want to create an environment where people feel that somebody's getting a little extra that somebody else is not getting, right? These are very specific requirements when we look at whether or not an accommodation is an undue hardship. And that's going to include the nature and cost of the accommodation itself, the overall financial resources of the facility that's making the accommodation, including the number of people that are employed there, and the effect of the expense on that facility. But then it's going to look not only at this one facility, but the overall financial resources of the entire employer, everything under that employer's umbrella, overall size of the number of employees and the type and location of the different facilities of that employer. So we're not just looking at one space, we're looking at the entire umbrella. The type of operation that the employer has, the type of structure and function of its workforce, its geographic separateness, they have to take all of this into account. And then they would look at the impact of the accommodation on the operation of the facility, including the ability of other employees to be able to perform the essential functions. Now, we do want to say that under final regulations, we did have a few additions to undue hardship to account for the difference between the ADA and that PWFA. So under PWFA, a possible reasonable accommodation, maybe that temporary suspension of an essential function. We talked about that a little bit earlier. Therefore, the rules list additional factors that should be considered when determining whether or not a temporary suspension of one or more essential functions would cause an undue hardship. And part of that would really be looking at the length of time that an employee would be unable to do the essential function, whether there's actually work for that individual to accomplish, the nature of that essential function that they're looking to suspend at this time, including how often they would typically do it. Whether the employer has provided a similar type of accommodation to others in a similar position that weren't affected by pregnancy, childbirth, or related medical conditions. If necessary, could somebody else be brought in to do that essential function? So these are all things that we think about to include whether or not that essential function can be postponed. And these are all really in this part of the guidance that we have. But in addition to just this aspect, there are 4 things that the Commission has determined are what we call predictable assessments. No matter what, the employer is going to have a very hard time saying these 4 things are an undue hardship. And the 4 things are allowing an employee to carry or keep water near them and drink it as necessary, allow the employee to take additional restroom breaks, allow the employee to work standing if their job normally requires sitting, or to sit if their job normally requires standing, and allow an employee to take breaks as needed to eat or drink. So these are saying that it doesn't alter, the terms and the meaning of a reasonable accommodation or undue hardship, but we're saying that it is very hard to show the significant impact of providing these 4 accommodations may have in the workplace. The employer still has the right to say it's an undue hardship, but they're going to have to really work to show how it would have such a negative impact on that work environment. Next slide, please. So we have the interactive process. Under the ADA, we have an interactive process, and it helps an employer and the worker figure out an effective accommodation. And so the commission really adopted that same concept under the PWFA, that employers will use the interactive process to identify the limitations and the adjustments or changes that are needed at work. And so it's just something that we want to make sure that it's understood that this can be an easy discussion. Once again, there's no magic words, there's no required steps. It could be just going and talking to your supervisor and saying, hey, I need to take the afternoon off to go to a doctor's appointment. And your supervisor says, no problem. That's literally as easy as that can be. Now, it could be something that is a little bit more involved. Maybe it is a suspension of an essential function, and the employer has to decide whether or not they are able to do that. And then now we're going to have a little bit more of that interactive process back and forth, looking at what the person does, how often they do it, the impact, what are some other things that could be done in its place. You're just going to have a little bit more of that give and take conversation. Under the PWFA, though, the employer cannot require an employee to take an accommodation other than the one they agreed to through the interactive process. So it is a key part of this discussion to have an accommodation. Next slide. Now, there are some discussion about the limitations on supporting document in our final regulations. The first thing I'm going to say is that an employer doesn't have to seek supporting documentation. The PWFA does not set out when an employer can ask for documentation. If the employer does seek supporting documentation, it can only be if it's reasonable under the circumstances. And in this sense, if you can just go and talk to your employer and your employer says, okay, I understand what's going on. Thank you so much for telling me you can have X accommodation. They don't have to have that documentation, right? But there are 5 examples of when seeking documentation is not reasonable. And I want to kind of go through that. When the physical or mental condition and the needed adjustment at work is obvious, i.e., the individual has a visible pregnancy and they need a uniform that fits, right? So that's going to be an obvious need. There is no reason to require that person to go get documentation to support the need for a larger uniform. When the employer already knows. So if the employer already has sufficient information and they have known from the beginning of the pregnancy that the individual is pregnant and that things are going to need to be adjusted over time, why do we need documentation to support that individual is indeed pregnant? When the employee is pregnant and seeks a predictable assessment, remember one of those 4 accommodations we talked about? If an employee is seeking one of those, why do we need documentation to support that the individual has the right to have those, right? Or that they need them. When the accommodation is related to pumping at work or time to nurse during working hours, where nursing during working hours only happens when there's a regular location of the employee's workplace, makes nursing possible because of the close proximity to the child. And then when the requested accommodation is available to employees without known limitations under PWFA, i.e. an individual got injured at work and work has a light duty program, they have to provide those same types of accommodations to individuals who are affected by pregnancy, childbirth, or related medical conditions if the employer does not need supporting documentation for that. right? So if somebody got injured at work and the employer doesn't need documentation to put somebody in light duty, and an individual is pregnant, they may not need documentation for that. Or if there's a situation where someone goes to regular doctor's appointments, and if somebody else goes to regular doctor's appointment that's not pregnant or has a medical condition related to pregnancy, childbirth, or related medical condition, and you require the pregnant individual to provide doctor's notes, but not the non-pregnant individual, now we have disparate treatment. We're treating people differently as a result of their pregnancy, childbirth, or related medical condition. Now, it could be as simple, like documentation, we're talking minimum. It could just confirm the physical or mental condition. It could just be a simple statement of the condition itself, right? Pregnancy, childbirth, or related medical condition doesn't have to be the sole, original, or substantial cause of the condition. And then ultimately, we just need to be able to describe the limitation at work and what may need to be changed as a result. Now, oftentimes I get questions here where we start really talking about employers are concerned that individuals may not be honest with their pregnancy or their reason to take time off. And a lot of times there's concerns about if an individual is saying that they are suffering from a miscarriage, how do I as an employer prove that that is indeed what is going on and that they're not just trying to take time off of work? For my role as an educator for individuals and employers alike, try to bring people back to understanding what an individual is going through if they are indeed suffering a miscarriage. Like, think about it. You are pregnant and now all of a sudden you are in the process of losing that pregnancy. This is something you may have wanted, you may not have wanted, but either way, your body is rejecting the pregnancy at this time. And you are going to go through sometimes significant emotional and physical results as a part of that. And that can happen it happens often, honestly, in the first trimester. It happens often in pregnancies in general, and nobody really talks about it. So we probably don't even know the number of individuals that suffer miscarriages. But what I try to explain to employers is that oftentimes a miscarriage is happening before an individual has even been to a doctor to confirm the pregnancy. Nowadays, doctors don't see you until possibly the 10th or 12th week if you have an uncomplicated pregnancy. And so if you're suffering a miscarriage at week 7, there is no doctor's documentation to support this. And this is a time where employers need to have empathy and compassion for their employees and understand what they are currently going through and provide them with an accommodation and with that compassion that you would hope that they would provide them with. That's where that limitation of supporting documents and the fact that the PWFA does not require an employer to seek it is very important. Next slide.
Okay, I'm back.
Hi, Isis.
We have a question from the first portion of the discussion. Someone asked, can your doula call in for her client? Can a doula do that as a representative for an employee?
Doulas are often considered forms of healthcare professions, and they work along with the healthcare. So yes, they can call in on behalf of the individual. Sometimes people are having home births, and it's the doula that would be able to verify the birth just happened. So absolutely.
Yeah, thank you for that. And then we also say, will these updates apply and be enforceable in military settings?
That is an excellent question that, Isis, I've never actually been asked. And I say that because the military at times has different regulations that have to be abided by. I would love if that person is comfortable reaching out to you to provide their contact information so that I can do the research and I can get back to them, because that's an excellent question. I don't have the answer for you right now.
Thank you. So you heard that, Christina. Thank you so very much for that. And another question, you spoke about the proximity of the child to the nursing parent, and then having to have accommodations for that. So the question came up, what if an employee needs to pump, but they're in a facility where the child is not necessarily present. Is that a reasonable accommodation?
Absolutely. So it's not only a reasonable accommodation for pumping. So pumping at work is a reasonable accommodation under PWFA. It's also a reasonable accommodation under the Pump Act, which is enforced by the Department of Labor. So the same time Congress and the president put in place the PWFA, they also put in they put in the law for the Pump Act. So we're just strengthening individuals' ability to be able to pump at work in safe, clean, and private environments.
That's great. Thank you so much. Those are our questions for this. Let's continue going on with the discussion.
Sounds great. Thank you so much. Okay, so there are certain prohibited practices that an employer can't do. We already talked a little bit about some of this, which includes they cannot make an in-person take an accommodation if that individual didn't arrive to that accommodation with the employer. So we talked about that one a little. But some of these other ones are, they can't just fail to make an accommodation if one is available, right? Or they can't fail to engage in the interactive process. They can't, as I said, require an employee to accept an accommodation they didn't reach during the accommodation process. They can't deny employment opportunities to qualified employees because that person needs or will need a reasonable accommodation. So the employer can't just assume somebody may need an accommodation, and they can't use somebody's known limitation or need for accommodation to decide not to promote the person, to maybe make a decision to let them go or lay them off. Any type of employment decision cannot be related here to a person's pregnancy or their need for an accommodation. Even if the employer is like, oh, this is just going to be too difficult on us, so we're just not even going to try it. We're not going to be looking at that. Employers cannot do that. We cannot, and this is a big one, employers cannot require an employee to take leave if another reasonable accommodation can be provided absent that undue hardship. This is so important for us to stress because at times employers will tell individuals, well, you just need to take leave. It's too difficult for us to provide an accommodation, or we're not even going to look at it. You need to take leave. And then the person exhausts all of their leave, possibly even before they've had the child. And so, yes, leave can be a form of a reasonable accommodation, but that's if the employee wants it. The employer cannot force somebody to take leave. And then the employer can't take any type of adverse action in terms or conditions or privileges of that employment. So an employer cannot hold somebody accountable or take adverse action because they're asking for or they're using a accommodation under the PWFA. And that goes into our next slide, in which we really talk about retaliation and coercion. These are also prohibited practices. These are prohibited the same way that they're given the same protections as Title VII and the ADA. So PWFA, once again, mirrors laws that are already in place, and it protects workers who participate in the EEO process. So it can protect individuals who are asking for an accommodation, or if they reasonably oppose actions that make it unlawful under the PWFA, right? Also, employers cannot coerce individuals to not ask for an accommodation or to take an accommodation that the employer wants them to take, even though there are other accommodations that the employer could provide. And they also cannot threaten or interfere with an individual exercising their rights or helping others exercise their rights under this law. The coercion aspect, we're borrowing directly from the ADA, interference provision. So once again, we're taking laws that are already in place and we're trying to make it easy for everyone to step into abiding by the PWFA. Next slide, please. When we talk about its relationship to other laws, nothing in the PWFA limits other laws that could provide more protections, right? Workers can actually bring claims to the EEOC under multiple laws. So maybe you come to us and you're like, hey, I have a PWFA and a Title VII claim, or a PWFA and an ADA claim. Maybe you're going to go to the EEOC and say, I have a PWF claim and an FMLA claim. or a Pump Act claim. Maybe it's PWFA and there's more state or local laws that you can also file against. Nothing in this provision prohibits an individual from, any other laws or any other protections that they may have. Nothing in the PWFA can require an employer-sponsored health plan to pay for certain types of procedures, and this is the same language that is adopted in Title VII. The EEOC has enhanced its administrative procedures, including revising materials, accompanying the notice of charge that we send out when a discrimination charge has been filed, and related our web pages just better to explain how employers can raise the defense, including religious defenses of why they can't provide a specific type of an accommodation. Next slide, please. And then just to quickly go over this, we have the same type of procedures under the PWFA as we have for the majority of the laws that the EEOC enforces, which is that you have to file with our agency before you can sue an employer in court under the PWFA. We have a lot of information about our filing process, and you all can have a copy of this PowerPoint in PDF form, so you'll be able to click these links. And then if you're successful at a lawsuit or a resolution of your charge, you can get relief in the workplace to include that accommodation. Maybe there's back wages that you were owed because you were forced to take leave. Maybe it's reinstituting the leave that you were forced to take, that there was another accommodation that could have been provided, or compensatory or punitive damages for that case. Next slide. Now, we definitely have some court cases that are developing that may impact the PWFA enforcement. None of those are affecting us right here, right now in the state of California, but I want to let individuals know about them. There's a case challenging the process of how Congress passed the PWFA, and that's out of the state of Texas. There's a case challenging some of the PWFA regulations. There's one out of the state of Tennessee. There's one out of the state of Louisiana and the U.S. State of Conferences of Catholic Bishops. I will say there was just an injunction put in place out of North Dakota yesterday. So some of these things are happening quickly, but none of these are affecting any other statutes that we enforce, and none of these have come and worked their way through the court yet. So this is still kind of when a new law is put in place, people are going to challenge it, and we're going to see what comes of it as we go. And then I did want to just take a quick moment with you and kind of walk through a couple of fact patterns just to make sure that we all have a really good understanding of that. If you wouldn't mind going to the next slide. Oh, so we are going to look at fact pattern 1 here, in which, just bear with me while I read it through. Nisha's a nurse assistant who is working at a large elderly care facility and is advised in her 4th month of pregnancy she needs to stop lifting more than 25 pounds for the remainder of her pregnancy. One of the essential functions of her job, though, is being able to assist patients in dressing, bathing, lifting, and moving them to and from their beds. So this typically requires a person to be able to lift more than 25 pounds. Nisha sends an email to HR asking not to be required to lift more than 25 pounds for the remainder of her pregnancy and requests to be placed in the workplace's established light duty program, under which employees who are hurt on the job take on different duties, while coworkers take on the temporarily suspended duties. So first, I just want to walk us through whether or not Nisha informed the employer that she has a known limitation, and did she request an accommodation. So in this fact pattern, Nisha's lifting restriction is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical condition, right? And she let the employer know that due to this work limitation, she cannot lift more than 25 pounds. So she is a qualified employee under the PWFA because she's just asking for a temporary suspension of an essential function. And she believes that she'll be able to perform that essential function, that lifting, in the near future. And just so that we have an understanding of what in the near future means, Under the guidance, we're saying it can generally be within 40 weeks. So within the time frame of a completed pregnancy or coming back from maternity leave, it could be within that time frame. It also appears that the inability to perform this function can be reasonably accommodated because they already have a light duty program that individuals who are put on the who are injured on the job have access to. So in this case, it does appear that an employer has to grant this reasonable accommodation of temporarily suspending being able to lift that 25 pounds, absent undue hardship. And it does seem that the employer has a program already in place that they can assign NISHA to, which is that light duty program. And just so that we all know, this is a kind of a from real life situation. This is a case that came out of the Supreme Court called Young versus UPS. It wasn't a elderly care facility, it was UPS, but everything else that's happened here is exactly the same type of fact pattern that happened in that case, where someone couldn't lift more than 25 pounds as a result of their pregnancy, and the workplace already had a light duty program in place for individuals who've been injured on the job. So just so that you know where we're pulling some of our fact patterns, they would be from real life. And then we have our second fact pattern. We're just going to run through pretty quickly here. We have Margot, who started working in a retail store shortly after she became pregnant. She's got an uncomplicated pregnancy, which is a blessing. Because she's not worked at the store very long, though, she's earned very little leave and she isn't covered under FMLA. In her 5th month of pregnancy, she asked her supervisor for the reasonable accommodation of unpaid time off beyond the leave she has earned to attend her regularly scheduled prenatal appointments. So in this situation, we have our known limitation, which is Margot wants to continue to maintain the uncomplicated pregnancy. So she wants to maintain the health of herself and her pregnancy. And she needs an accommodation by having leave, even if it's unpaid, and she's communicated this to her employer. Next, we'll just say that Margot is qualified under the PWFA because she can perform the essential functions of the job with the reasonable accommodation of just having leave to attend healthcare appointments. So she is qualified. Now, once again, her employer has the opportunity to say that this is an undue hardship. But absent that undue hardship, Margot's employer has to grant an accommodation of unpaid time off. Next, I'll give you a slide that, once again, I know that you will have access to later on, but we do have additional resources, and a lot of them. We have resources from the EEOC, we've got resources from the Department of Labor, and even resources from the Job Accommodation Network, who people may or may not be familiar with, but it is a nonprofit organization that provides ideas on how to accommodate individuals within the workplace. And so that's one of those things that's always highly important for individuals to have. And then we want to make sure the individuals have my contact information. And so I think we'll be able to share that information with everybody as well. Next slide, please.
Hello.
Hi,
Hi. In the interest of time, I have just one more question. And that is, you talked about the employer in fact 2, you said the employer, or fact 1, the employer had asked for or provided accommodations because they had a light duty program. Should there be an employee who asks for accommodations, can an employer reassign them if they don't have a light duty program to a lesser or lower level position? Would that be an okay accommodation for an employer who's dealing with someone with a prolonged issue during pregnancy or postpartum?
So what we would say is, first, like, reassignment is kind of last resort, right? So first, let's see whether or not we can provide an accommodation that keeps that person in their regular job. If for some reason that's not available, absent undue hardship, then we can look at reassignment. Now, reassignment can be to an equal position, or it could be to a lesser position. An employer never has to promote an employee, and they do not have to create a position for that individual. However, when an individual has that type of situation occur, they are reassigned. They do not have to apply. nor do they have to compete for that position. It's a reassignment through the accommodation process. And those are two very big issues that we see arise with employers, where they tell people that they have to apply and they have to compete. And in reassignment under an accommodation, they don't.
Yeah. Okay. And that would happen during the interactive process, right? That discussion would happen during that time.
Correct. Absolutely. Okay. So it's during that time frame that we're trying to see, can we accommodate? Can we keep you here? What can we do? And if not, what are other options available?
Okay. Well, I have to say thank you so very, very much. I'm going to move on to our next steps. And then I'm going to announce how we can connect should you decide that you may have a case or you know someone who does, how you can fix that. So after this, we are going to follow up with an email to everyone who came. So you'll have an opportunity to look at these slides again and keep them. And then also the resource page. A copy, like I said, a copy of the presentation will be there. If you decide, hey, I want to follow up, Daisha, thank you very much for that. I want to follow up with this question because it didn't get answered here, and maybe it's too personal to ask on this particular discussion. You can send that email to info@CaliforniaBlackWomenCollective.org or CABWCEI right here on your screen, and we will put you in contact directly with Nikki and her team so somebody can get with you. We know you have private matters and it's not for public consumption, so we want to make sure that we respect that. So we will connect you directly. And then after that, please stay connected with us. Check us on all platforms at CA Black Women's Collective. Thank you so much for coming.
Thank you all.